You might have wondered what happens if a barrister gets a criminal conviction. Can they continue to practice? Or even, what if they step out of line on social media with what they say? Let's say they get into an argument online. Well, like all other professionals, barristers are regulated. Barristers can be disciplined, they can be fined, they can even be suspended for a period of time, and they can even be disbarred, meaning they can never practice again. Just like doctors, they can have their practicing certificate taken away if they bring the bar into disrepute. However, some people believe that barristers take some kind of oath or swear some kind of pact with the bar or the general counsel of the bar or even the courts. But that is not true. But like any other profession, we are regulated. So for this video, I had the great pleasure of interviewing the Director General of the Bar Standards Board, Mr. Mark Neal, to talk about the role of the Bar Standards Board and what the Bar Standards Board looks at if barristers are behaving badly. Let's get into it.
So, Mark, a very warm welcome to the channel. Mark joins us with a wealth of experience. Over 9 years, I see, at the Financial Services Compensation Scheme from 2010. Not the easiest time to have taken up that role, but clearly done a fantastic job. And in fact, point of trivia, it was your predecessor, Dr. Vanessa Davies, that called me to the bar some years ago.
Oh.
So welcome, and obviously to our Alan Robertshaw, who is no stranger to the channel. Mark, thank you for joining us. We thought we'd ask you, rather than we explain, would you like to explain what the role of the Bar Standards Board is and what it's not?
Yes. Well, look, it's very good to be with you, first of all. I'm delighted to join the channel for the first time. The Bar Standards Board is, in a nutshell, a public interest regulator. That's to say, we're here to ensure that the bar works well for consumers. And the origin of that lies in the Clementi report of 2005, that found that the existing self-regulatory regime that applied across the legal professions wasn't working as well as it should do for consumers. The government then legislated in the Legal Services Act of 2007 to introduce a new regulatory regime, which essentially required the existing regulators, the Bar Council in the case of the bar, to establish independent regulatory arms. And that is the origin of the Bar Standards Board. We were the regulatory arm established back in 2007 by the Bar Council to give effect to the Clementi reforms and that new legislation. So what do we do? Well, the Act itself sets out some regulatory objectives to which we must have regard in carrying out the regulatory functions previously exercised by the Bar Council. And I would say that those regulatory objectives kind of divide into kind of two broad categories. There's one set of regulatory objectives that's really about the integrity, the independence and diversity of the profession itself. So we in the Bar Standards Board act as the gatekeepers for the profession. We set the standards that aspirant barristers must meet in order to join the profession. And we also police conduct within the profession after that, in order to give effect to those legislative requirements for the profession's integrity and independence. But then there are also a different set of regulatory objectives that are much more to do with how well the profession is serving the public as consumers, and they're to do with access to justice. They're to do with public understanding of legal rights and duties. They're to do with a competitive market. So alongside those duties that we have to promote the integrity and independence of the profession, we as the regulator in exercising our functions also need to look at how well the profession as a whole is serving the public interest and the public's interest in access to justice, the rule of law, and a competitive and easy to access market. So I hope that gives you a good indication of what we do.
Indeed, it does. And you spoke a lot about consumer focus. Now, I speak a lot about consumer law on my channel. Lots of our viewers will be interested in what they can and they cannot talk to the Bar Standards Board about. There's obviously different ways of, I don't like to use the word complaint, I prefer feedback, but there are different ways to complain and different bodies to complain to. How about some of the things that the Bar Standards Board will and will not consider, let's say, if a consumer of legal services is unhappy with those services?
Okay, well, let me again kind of divide it into two parts. In terms of our responsibilities for the integrity of the profession itself, if a consumer has concerns that an individual barrister has breached our code of conduct, then that consumer can make a report to us about the barrister concerned, and we will assess that report. It varies from year to year, but on average, we receive about 2,500 reports of that kind every year. The majority of those reports we don't take forward after assessing them, but a minority, round about 5 to 10%, will then result in an investigation. And where that investigation does give grounds for concern that a barrister has breached the code of conduct, there may be a case taken to the Bar Tribunal and Adjudication Service. So that's essentially our role in policing the integrity of the profession. But as I said, we also have an important role in terms of the way in which the profession itself serves consumers. And there, we're always open to representations from consumers and consumer bodies about how effectively the bar as a whole is serving the consumer interest. So, for example, if consumers feel that they don't have a wide enough choice when they seek to instruct a barrister, that might be something they could come to us to talk about. They might come to us with more general concerns about standards in the profession. We're always kind of open to hearing about areas where professional standards could change in response to changing technologies or changing consumer needs. So to give you an example there, we have in the recent past set out competencies for work in the youth courts. We've set out competencies for work in the coroner's courts. And that responds to feedback from consumers and consumer bodies about the changing needs in those legal contexts.
I was just going to say, because people might be unaware that the BSB gets involved at sort of a very early stage when it comes to sort of making sure the profession delivers, because I do a lot of the advocacy training, and also with the qualifying sessions, one of my roles was I was the internal observer. And just to explain briefly what qualifying sessions are, they're sort of elements of compulsory training for people who've been called to the bar, but before they're sort of fully allowed out there in the big bad world, in the first sort of few years of their practice, they have to, before they're allowed, they have to attend, I don't want to call them lectures specifically, because they're more than that. But, the BSB gets very involved in making sure that what the Inns of Court, for instance, are teaching the young barristers. You supervise that. And also when we do the advocacy training, you supervise the course materials and the way we're presenting. So I don't know if you want to talk a little bit more about that, because, it's not just a body that people complain to. It's a body that gets involved very, very early on and tries to ensure sort of like the way we do things is the best way possible. So I don't know if you could talk a little bit about that, perhaps.
No, I'd be very, very pleased to. I mean, what you're pointing to there is our role as the gatekeeper for the profession. We set the qualification standards for the bar, and indeed we've reformed those qualification standards in the last decade in order to maintain high standards, but also to promote affordability and accessibility and flexibility. So we require that any barrister, before he or she can practice, must have obtained some academic qualifications, usually through a first degree. Then we set some standards for vocational training, for bar training, which the bar training providers meet through the courses that they provide, and we're seeing increasing diversity of provision there. And then finally, we set the standards for on-the-job training through pupillage. So in all those three elements, we're very closely involved, and that's how we ensure that any barrister who receives a practicing certificate has demonstrated that he or she has the skills, knowledge, and understanding that we require of all barristers, and which we set out in the professional statement.
I saw some conversations just recently on Twitter about universities and training and this sort of thing, because obviously for viewers watching may not be aware that it used to be entirely contained within the Inns of Court for training for barristers, and later it was spread out to other universities. I myself did it at BPP, University Law School.
Yeah.
Do you have any thoughts on that? I mean, it's met with mixed views, both among the profession, among the public that are online, as to whether it should have remained within the Inns of Court, or what are your general views on that?
Generally speaking, Daniel, I think the current arrangements are working well. I mean, if you're interested, you will find some quite extensive evaluations on our web pages. But I said a little earlier that we reform bar training with a view to standards, accessibility, affordability. And we've seen quite significant improvements in all those respects. We brought down the costs of bar training to students, which is important. But we've also seen a wider range of courses provided by bar training providers. And indeed, I think a very exciting development. We're also at the moment actively supporting moves for an apprenticeship route to the bar. And I certainly personally would very much like to see that come to fruition. But all these routes must meet the high standards that we set and which are enshrined in the professional statement. So there is absolutely no dilution of standards. What we have, however, seen, which I think is very important and encouraging, is growing diversity on entry to the profession. So if you now look at pupillage and the early years of barristers' careers, the bar is now very closely a reflection of the society which the bar serves. That's great. There are still challenges on diversity. We need to see that diversity at junior levels carry through to more senior levels and to keep KCs. But it's a great and encouraging start.
Absolutely, and I recall discussing with Dr. Davis some years ago when she had your role about the work-based learning opportunity for pupillage, and I certainly support it. I think it's one alternative to the traditional route that I think a lot of people will find enjoyable and useful. Al, any further thoughts, questions on that?
No, I mean, like I said, this is, I think a lot of people will be surprised. Like I said, the Bar Standards Board isn't just there to tell barristers off and things. Post facto, it's how it is this sort of much broader thing. And perhaps one thing I'd like to talk about is how the BSB engages with the profession. Now, I had the experience, Mark, when I met you a little while ago in Bristol, where you have these round tables. And also, what was interesting there again is it's all the stuff about compliance and regulation within chambers. It's setting standards, it's setting procedures for people, to follow, to hopefully ensure that things go right from the start and don't need to be sort of corrected or remedied or penalised. So perhaps you could explain a little bit about how you engage both with the profession and also with the public.
Yeah, well, we try and engage, as much as we can with the profession, because the profession's views are, hugely important to us. The roundtables you mentioned are to do with an initiative we began to look at the role of chambers and how we as the regulator can be much clearer about our expectations of the role which chambers should be playing in promoting high standards throughout barristers' careers, in promoting diversity and in promoting access. And very much from the point of view that the better the job chambers are doing, the less there needs to be regulatory intervention, because we will be able to rely on the work that chambers do. So as part of that, we reached out. My chair, Catherine Stone, and I did a whole series of roundtables in all the circuits. It was really valuable in gaining insights into some of the challenges that chambers face. And in the light of that, we will be coming back with another consultation document with some firm proposals early this autumn. And we then intend to repeat those roundtables. So you will be seeing us again in Bristol, either later this year or very early next, and we'll be very pleased to hear your views on the proposals we'll then be bringing forward.
Perhaps also, just from a practical point of view, sorry about my throat's terrible today, but from a practical point of view, just how many people? Because perhaps people might be surprised as to how the BSB functions, how many people actually work for the BSB, how it is funded. The fact that a lot of people give up their time effectively for free to sort of make it work.
Well, there are about 100 people who work exclusively for the Bar Standards Board. We are part of the Bar Council still, so there are another 20-odd people who jointly serve both the Bar Council and the Bar Standards Board, providing things like financial and IT and facilities services. Overall, we cost barristers about 16 or 17 million pounds a year. And those costs are recovered through the practicing certificate fee, which, as you will know, you pay every year in the spring. And that fee is graduated according to barristers' fee income.
Mark, perhaps you could tell us a little bit, because people might be confused as to what, for instance, the difference between the BSB and the Legal Services Ombudsman is. So perhaps you could just explain a little bit about the different roles there.
Well, it's a good question, an important one for consumers. And indeed, we have a good relationship with the Legal Services Ombudsman. In a nutshell, the Legal Services Ombudsman is there to deal with complaints about your own lawyer. So if you as a consumer go to a solicitor or instruct a barrister and you're unhappy with the service that you has provided to you by that lawyer or barrister, then you should take your complaint in the first instance to the solicitor's office or to the barrister's chambers. But if you don't get satisfaction there, then you can take your complaint to the legal ombudsman, and the legal ombudsman will look at that complaint about the service that you received. That is rather different from the role that we play as the regulator. We're there to deal with breaches of professional conduct, the code of conduct that we prescribe for barristers in discharging their professional responsibilities. And we, the Bar Standards Board, would get involved where a consumer or indeed any other stakeholder had concerns that a barrister had breached that code of conduct. So I hope that is kind of a reasonably clear explanation of the difference that the different roles we perform. But cases do move between the Legal Ombudsman and the Bar Standards Board, and we certainly take a keen interest in the kinds of issues that the Legal Ombudsman sees as a result of its handling of complaints, because that's quite an important source of intelligence for us about how well the profession as a whole is serving consumers.
And following on from that, I think an interesting point is that you regulate barristers' collective behaviour, both in their professional life working as a barrister and sometimes in their private life, depending on what they're doing and where they are, because as we know, but the general public probably don't know, that some of our rules apply at all times, not just when providing legal advice or attending court. And so we're moving now towards, I think, an area that needs to be well defined. And as you can come on to talk about your upcoming social media policy, if you're happy to, where we know there are complaints about what barristers do and say and how they behave online. It's a very public forum. I don't mind saying I've had more than one complaint about my videos because someone doesn't like my opinion in some of those videos. But obviously, unless they cross a certain threshold, that is not something that you look at. So perhaps you'd like to talk a little bit about that.
Yes, we have just completed a consultation which, as you say, aims to clarify our interest in conduct in non-professional life and in the use of social media. If you're interested, you will find the relevant board papers from the meeting on the 27th of July on our website, and we'll be publishing the final guidance later this month. But as you rightly say, Daniel, our code of conduct does apply both in professional and non-professional life in some circumstances, particularly where conduct bears on public confidence in the profession, or where a barrister's own integrity and independence are at issue. And in that respect, we're no different from other professional regulators. For example, I'm a former civil servant, and senior civil servants have even more stringent restrictions, for example, in terms of what they can or can't say in public about political issues. The position of barristers is much less constrained than that, but where barristers are using social media, they do need to be aware that comments can reflect back both on themselves and on the profession and on their own independence and integrity. And it's in circumstances where comments could damage the reputation of the bar as a whole, or call into question the independence and integrity of the profession, that we might have a regulatory interest.
Are there perhaps one or two examples of things that the Bar Standards Board has been particularly concerned about, or is it more a general overview that you're looking at?
It's a general. We're generally concerned to clarify, the regulatory boundaries here, and in particular to give barristers clear guidance about how we seek to strike the balance between our regulatory interests on the one hand and barristers' rights of free speech and freedom of expression on the other. And I hope the guidance does that. Clearly, where barristers are acting visibly as a barrister, that is more likely to engage a regulatory interest than where they're acting purely in a private capacity. And as I think the guidance makes clear, we're more likely to be interested in the manner in which barristers express their views than in the substance of the of the views themselves, though there might be some circumstances in which we would also take an interest in the substance of views if they were overtly discriminatory, for example.
Mark, one thing I've noticed when I speak to people is there are often quite a lot of misconceptions about the sort of, what the BSB does and how the BSB works. So is there anything you'd like to sort of clarify for both our sort of, lay viewers, but also for the profession?
Yeah, good question, Alan. I think one thing I would kind of like to make clear is that as a regulator of the bar, we're not the enemy of barristers. Barristers share our commitment to the profession's reputation, integrity, and diversity. But we do have this important role also to represent the public, to represent consumers in judging how well the bar is serving the consumer interest. And that's not something that individual barristers, as part of their day-to-day practice, will necessarily see quite in those terms. Barristers working day-to-day are not asking questions about whether the bar of the future will have enough barristers of different specialisms to meet public demand, are not asking questions about whether the public receives enough choice when solicitors refer them to the bar, are not necessarily thinking about the degree to which consumers are well informed about what barristers can and can't do. And so all those questions about how well the market works for consumers are kind of important ones for us, but maybe less in the forefront of individual barristers' minds.
Thank you so much, Mark. We're mindful of the time that we're taking up, but we're very grateful for you to join us on this channel to clear up some misconceptions, hopefully educate the public and, dare I say, other barristers at the same time. So we're very grateful for your time, and thank you so much for joining us.
Well, thank you very much. I very much enjoyed it, and I'd be delighted to come back and talk some more at a later date.
You'd be very welcome. And to everyone else, thank you so much for watching.